New Zealanders.
Mr Chair.
I call the Honourable Member Moana Maki.
Thank you, Mr Chair, and I'm happy to be filling in for my colleague Louisa Wall, who can't be here tonight. And I was also happy to be a member who sat in on the Government Administration Select Committee for the passage of this piece of legislation. Can I first of all thank members for their interest in this debate and the tenor in which the debate has been carried out. For the SOPs that people have drafted, I appreciate that they're done full sincerity of trying to get the best possible law that we can, and I'm hoping that my contribution may actually be able to provide some clarification. Because I think we're actually a lot closer than members might believe in terms of being in agreement on a lot of these issues. And the Government Administration Select Committee worked very, very hard on the issues that have been raised, both in speeches and in SOPs, because we knew that with dealing with the area of the Bill of Rights, the Human Rights Act, we had to be very careful about the wording, we had to be very careful about unintended consequences that might come from drafting that hasn't had that kind of consideration given to it. And that's how we came up with the wording that we did. So if I can move first to the main issue that people have been raising, which is the protection of religious freedom and the concerns that churches and religious organisations might be forced to marry gay couples against their own beliefs. Well, members may or may not know that Section 29 of the Marriage Act, which has been in place since 1955, actually states that a marriage licence shall authorise but not oblige any marriage celebrant to solemnise the marriage to which it relates. Now, that's been in place since 1955. There hasn't been an issue with that at all. Not even since civil unions were passed in 2004 has this ended up going into some kind of legal stoush. But concerns were raised that the refusal to solemnise on the grounds of sexual orientation might breach the Human Rights Act. Now, the Human Rights Commission, which is the body that would investigate any such claim, have said they would not uphold a complaint of discrimination against a celebrant who declined to solemnise a marriage. So that's in place there as well. So there is that protection of Section 29, but to put it beyond doubt, because we recognise the genuine concerns that were being raised by submitters, the Select Committee actually proposed an amendment to make it clear, because we appreciate that the Marriage Act predates the Human Rights Act and the Bill of Rights Act, to make it clear that in this day and age we do not believe that freedom of religious expression should be overruled by this piece of legislation, and that any celebrant acting on behalf of or appointed by a church can refuse to marry any couple if to do so would contravene their religious beliefs. Now, we deliberately included celebrants in that, so this applies not just to religious ministers but to celebrants who are associated with those religious organisations as well. So the issue has now come down to what we call independent celebrants, who are not acting on the authority of any church. And I want to remind members of the very important distinction between the role of church and the role of state here. Religious celebrants are acting on behalf of the religious organisation to whom they belong and the state. Independent celebrants are acting solely on behalf of the state. And I want to direct members to Section 5 of the Bill of Rights Act. This is the official information that we got from officials, which says that indeed it does allow rights affirmed under the Bill of Rights Act to be justifiably limited. Accordingly, an exemption could be justified where it would be contrary to the recognised purpose of religious bodies and approved organisations to require their celebrants to solemnise certain marriages. In contrast, independent marriage celebrants and registrars are appointed by the Registrar General to perform a public function, not to promote their own religious or personal beliefs. Now, that separation between church and state is very important, because if we now say that these public servants effectively carrying out a public function are not subject to the Human Rights Act, then what does that say for civil servants who work in the Department of Internal Affairs, for example, issuing the marriage certificates? And what the Select Committee did was we left the door open to those celebrants who do have firm religious beliefs to go to their church and have their church appoint them as acting under their authority. That way they are given the full protection of this new clause which the Select Committee has put in. So I believe we have covered off that issue very, very carefully. And I would be concerned if we were to vote up amendments which might muddy that, because it was a very deliberate decision to make a separation between church and state, but to provide an avenue for those celebrants who are currently independent who want to be able to exercise their own religious beliefs and their own religious freedoms. So, and can I just point out an issue of reality, which is this is actually unlikely to be a problem. on one of the most important days of your life, I don't think that any couple is going to want to have someone presiding over their ceremony who doesn't want to be there and who is only there under threat of legal action. That's why this has never been an issue since 1955. It hasn't been an issue since the Civil Union Act came in 2004. I don't believe it's going to be an issue going on into the future. I accept the principle of the matter, but in reality, I do not believe that anyone is going to be, Mr Chair,
The Honourable Member
under genuine threat of prosecution. So we come to the issue of the use of church buildings and the ability to refuse supply of facilities or services. Can we be clear that churches will not, across the board, be required to provide their facilities for same-sex marriages if this bill passes? And I want to read to members from the Human Rights Commission opinion on this. It says, in part, this reflects the fact that religious ceremonies and services are not an area of public life covered by the Human Rights Act. Similarly, ceremonial or consecrated spaces or any other religious premises that are not made available for the public to hire are not covered by the Human Rights Act. However, when a religious organisation provides goods or services or accommodation to the public, they are held to the same non-discrimination standards as others. And this was actually backed up in the legal opinion of Family First. So the idea that this is going to be carte blanche, everyone has to provide their facilities, is not true. Can I say to members that this has been the law for 20 years, that if you provide a commercial service, you must do so in an anti-discriminatory way. You may not discriminate on the grounds of sexual orientation. And if members want to do that, then they should put up a bill to amend the Human Rights Act, which is actually where this sits, not the Marriage Act. Because it is a major winding back of our human rights legislation if we now say that the law that's been in place for 20 years, where we haven't had any issues, is now going to try to be wound back by an amendment to the Marriage Act. So can I then come to the issue of freedom of speech and concerns that the passage of this Act may mean that some people cannot express their views on gay marriage. And one thing that came up was there was Section 56 of the Marriage Act, which none of us, I believe, knew existed, which makes it an offence to deny the validity of someone's marriage. And there were fears that this could be used against those now who refuse to recognise the validity of same-sex marriages. Well, it's never been used. This penalty has never been exercised. It's a £100 fine. And the Select Committee basically said, let's get rid of it. It's no longer appropriate. So that fear, members do not need to worry that Section 56 may be used against people who speak out against same-sex marriages. If I can move on to the issue of the referendum and the SOPs that are in place. And the Honourable Winston Peters said, so we're saying you can have a referendum on asset sales, but not on this issue. And I want to say absolutely that is not the case. Yes, you can have a referendum on this issue, but there is a process that we go through in this country to initiate referenda, and that is absolutely open to members who oppose this bill, just as it was to members who oppose asset sales. What the SOPs are actually asking we do is to bypass that process, is to override that process that is currently in place. And from my own personal view, I do strongly believe there are some issues that should not be determined by referendum. And I do not believe that the rights of any minority group should be subjected and only upheld on the will of the majority. And members mentioned Switzerland, where they do these issues by referenda all the time, where as a result, women didn't get the vote until 1971. 1971, and I want to tell members the reasons that were given at the time were that men and women were fundamentally different. Men and women were fundamentally different. And on the Federal Department of Foreign Affairs website, they actually point out saying...
Order. Sorry to interrupt, member. Can I just remind members that you can interject on the speaker who has the floor, but you can't interject on each other when you don't have the floor. If you want to do that, then it's not in this place. I call the Honourable Member Moana Maki.
Thank you very much, Mr Speaker. So, now, what they said at the time was one of the reasons given as to why women shouldn't be given the vote was, quote, it wouldn't promote equality because their natural modesty would stop them going out to vote when pregnant, and since rural women have more babies than those in towns, this would give an unfair advantage to the latter. So I think there are some intrinsic dangers in putting an issue like this to vote at a referendum. Now, more generally, I want to address the issue that a number of people who've emailed us have talked about children and what this might mean for children. And I think we all agree in this House that marriage does afford benefits, both legal and social. It provides stability. My question to members would be, why should every child in this country not have access to those benefits? Why are we saying to children who are currently living in same-sex relationships, and they're there now, if this bill doesn't pass, that isn't going to change, that they don't get the full protections and benefits of marriage because some adults disagree with the relationship that their parents are in. I think if we're looking at the rights of children in this country, then this bill actually does afford more legal rights and protections, as well as social protections and stability to those children who are being raised in those families. In terms of other matters, very quickly, this will address an issue for transgendered people where when they go through that process they have to annul their marriage or choose to remain listed as their original sex on the birth certificate, which puts a number of them in a horrible situation. This will address this. And some members say some gay people don't want this. That's true. They don't have to do it. But if they don't do it, it will be because they choose not to do it, not because the state knowingly and deliberately excludes them from the institution.
I call the Honourable Member Dr. Rajan Prasad.
Thank you, Mr. Chairman. I